Welcome to our deep dive into a major shift in U.S. immigration processing, national origin being treated as a formal negative factor in some green card reviews. In this video, we'll unpack what changed, who is affected, how to respond strategically, and what documents can help mitigate the increased scrutiny. We'll also include a brief quiz to check your understanding and finish with actionable steps you can use right away. Here's the roadmap for today's video. First, we'll outline the context and the policy shift. Next, we'll detail what changed in practice and who is impacted. Then we'll move into strategy and a concrete evidence checklist. We'll also touch on ethical debates, include short quizzes to reinforce learning, and end with key takeaways. Disclaimer: this material is educational and not legal advice. Immigration policies and their implementation can change rapidly. Your situation is unique, and you should consult a qualified immigration attorney for personalized guidance. Let's set the stage. The current discussions and policies represent a shift, integrating broad travel restrictions and related national security frameworks into the eligibility assessment for long-term immigration benefits. Under this approach, an applicant's country of origin, if tied to past travel bans or security concerns, can be counted as a significant negative factor. This elevates generalized geopolitical designations within individual adjudications, even when the applicant satisfies all standard criteria. Practically speaking, the change introduces a formalized negative factor tied to national origin, when that origin is associated with past broad entry prohibitions or enhanced security concerns. Previously, officers focused on individual eligibility and discretionary considerations specific to the applicant. Now, a generalized country-level designation adds a higher burden. This can apply whether the applicant is abroad or already in the United States pursuing adjustment of status. The impact spans multiple categories. Family-based applicants, including spouses of U.S. citizens, may face more rigorous questioning and evidence requirements. Employment-based applicants, even those backed by major corporations, can encounter the same elevated burden. Students and researchers changing or adjusting status may see additional delays or requests for evidence. Crucially, being lawfully present or well-sponsored does not eliminate the effect of the country of origin negative factor. On the left is the traditional approach, a case-by-case focus on individual merit and eligibility, with security checks tailored to the individual. Standard burdens of proof and more predictable timelines predominated. On the right is the new reality for affected nationals. A generalized country factor can weigh heavily, sometimes overshadowing individual merits. The security lens expands from the person to the country of origin, resulting in a heightened burden of proof and a greater likelihood of delays, requests for evidence, or denials. To respond effectively, start by mapping risk. Identify whether your country of origin has been implicated in broad restrictions. Then front-load documentation of good moral character, including community letters, volunteer work, and tax compliance. Demonstrate strong U.S. ties, such as employment history, housing, education, and family commitments. Provide security transparency with thorough records of travel, visas, and compliance. Over-document stability with address and employment continuity and financial records. Prepare in advance for potential RFEs or NOIDs by drafting templates and indexing exhibits. Finally, collaborate with counsel to build a direct, credible narrative that addresses the country of origin negative factor head-on. This mind map organizes the mitigation plan. At the center is mitigating the country of origin negative factor. Branches include good moral character, U.S. ties, security transparency, stability and reliability, legal preparation, and evidence quality. Each branch lists specific documents or actions, like volunteer records and tax returns for character, employment and housing for ties, travel records and prior visas for security transparency, address and employment continuity for stability, coordinated counsel strategy and interview preparation, and meticulous translations, certifications, and indexing to ensure evidence quality. Use this checklist to gather and organize documents. For character, community letters, volunteer records, clean background checks, and tax transcripts. For U.S. ties, employment verification, pay stubs, leases or mortgages, school records, and affidavits from family. For security transparency, I-94 history, prior visas, travel itineraries, and police certificates where appropriate. For stability, continuity in address and employment, plus banking and credit evidence. For compliance, proof of maintained status, and timely filings. Ensure quality control through certified translations, notarizations where needed, and an organized exhibit index. Before filing, perform a gap analysis to identify weak areas and address them proactively. Organize your evidence using a consistent exhibit index and labels. Include a cover letter that concisely explains how your documentation addresses the country of origin negative factor. Obtain third-party corroboration for critical claims. Practice a coherent narrative for potential interviews to ensure clarity and consistency. Quiz time. The question is, under the new approach, what is treated as a formal significant negative factor during certain green card reviews? The options are A. Length of U.S. residence, B. Country of origin linked to prior broad restrictions, C. Employer size, and D. Marital status to a U.S. citizen. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is B. The policy shift elevates a country's prior inclusion in broad restrictions into a significant negative factor within the adjudication process. Second quiz. Who can be affected by this negative factor's heightened scrutiny? Options are A. Only applicants outside the U.S., B. Only family-based applicants, C. Both applicants abroad and those filing adjustment of status within the U.S., and D. Only employment-based applicants at large companies. You may pause the video now to think about the answer. We will discuss the answer in the next section of the video. The correct answer is C. The heightened scrutiny can apply to applicants outside the United States and those filing for adjustment of status within the country, across both family-based and employment-based categories. This timeline shows typical adjustment of status stages under heightened scrutiny: a pre-filing assessment, intensive evidence gathering and indexing, filing a front-loaded packet, biometrics, preparation for potential RFEs or NOIDs, the interview and clarifications, and the final decision. Delays are most likely from filing through interview, where the negative factor can trigger closer review and additional requests. The key points are: first, national origin linked to prior broad restrictions can be weighed as a formal negative factor. Second, anticipate higher burdens of proof and potential delays. Third, front-load evidence of character, ties, security, transparency, and stability. Fourth, prepare for potential RFEs, NOIDs, and interviews with a coherent narrative. Finally, consult qualified counsel to adapt the strategy to your specific circumstances. There is a vigorous debate. Critics argue this approach risks blanket discrimination by elevating broad national labels over individual merit, legal eligibility, and demonstrated ties. Supporters emphasize risk management and national security. Wherever one stands, applicants must navigate the current framework pragmatically while preserving their rights and preparing comprehensive evidence. Here is a simple Markdown-style outline for a cover letter. It identifies the applicant, basis of filing, and summarizes how the packet addresses the country of origin negative factor. It lists exhibits by category and concludes with a statement emphasizing lack of security risk and strong U.S. integration. Use this as a template and adapt to your facts. To summarize, the policy shift allows a country of origin designation to be counted as a formal negative factor. This affects applicants both abroad and within the United States, across family and employment-based categories. The best response is to front-load a comprehensive, well-corroborated record. Plan for potential RFEs, NOIDs, interviews, and added delays. Professional legal guidance can be decisive. Thank you for watching. If you found this helpful, please like the video, share it with someone who might benefit, and subscribe for future updates. In the comments, let us know your questions or experiences navigating heightened scrutiny so we can address them in upcoming videos.